So y'all go sign that, and then I'll go over everything with you in just a minute. Probably you want to get that done, and then I'll take care of your other ones while it's fresh. Mr. Samuel on Eric Hebert.
Yes, you are.
Eric. Yeah, I mean,
Good morning, Your Honor.
Good morning, sir. How are you?
Great day.
Good morning, sir. Are you Eric James Hebert?
Yes, ma'am.
And Mr. Hebert is here in cause numbers 21-37340, which is a motion to revoke probation on a driving while intoxicated third or more. And then we've got 21-37341 on a motion to revoke for deadly conduct, discharging a firearm. And what is the announcement?
Yep. Your Honor, I yield to the state. We discussed the case.
Judge, the last time we were here on June 9th, the court asked us to expedite that new arrest, DWI third. We did. We got with Niederland. They submitted the case, got with Ms. Hannon at the lab. She actually completed the lab and sent it to us last week, July 16th. So we'll be, I can try to see if I can get it indicted in the morning. If not, it'll be next
Next week.
Wednesday. We can take care of all three of those together whenever the court's ready.
So let's do this. I'll just do a normal reset. That'll give you time, once it is indicted, to get the discovery and everything you need. That representing yourself is a terrible, terrible idea, because you will be required in any proceeding to know all of the rules and everything, just like the lawyers. You have to follow the rules of evidence, the rules of Texas evidence, the rules of Texas criminal procedure. Whether you think they apply to you or not, they're going to apply in this court. So what happens is, if you get in front of me, it's one thing. We can have this little bit of patience and I'm going to go, but you get a jury in there. And if you want a jury trial and you want to present a case to a jury and you're not doing it right, it's just going to get worse for you. I'm going to have to shut you down. I'm going to have to not let you enter certain documents in if you don't know how to do it properly. You're not going to be able to question certain witnesses if you're not doing it properly. So it's really, really a terrible idea to represent yourself. If you insist on that, I can go through some questions, but I'm assuming, am I correct that you don't have any formal legal training? Have you ever been to a school or any kind of legal training? Okay, so then am I right to say that you don't know what the Texas, those rules are and how to pick a jury or enter in evidence certain items at a trial and things like that, correct?
Yeah,
You do know how to do that?
to a degree, yes, I do.
So you would know how to properly, under Texas law, pick a jury and go to trial. I'm gonna tell you this, I didn't even know how to do it when I graduated law school. There's no way you know how to do that. And I'm telling you this for your own good. It takes practice and it takes sitting with people and learning and going to school to be able to really represent someone. I, as an attorney, and I bet these attorneys will tell you the same, if they were in trouble, wouldn't represent themselves. One of the first things we're taught in school, I was taught, don't ever think if you represent yourself, you have a fool for a client. That's what our professors told us. Because you're not able to represent yourself even as an attorney. You should get another attorney. So I really, really strongly recommend that you let Mr. Rojas help you. Mr. Rojas is a great attorney. He understands this process. He has a good relationship with the district attorney's office. He will either get you the best deal, or if you want to go to trial, we'll get you an attorney, Mr. Rojas or someone else that can take your case to trial. So if you want to go to trial, the first thing you have to do is reject a plea offer. So if Mr. Smith has made an offer, then you need to sign something that says, I don't want that. I want to go to trial. Mr. Rojas can get that this morning. It's not committing you to anything other than saying, I don't want to take that deal. I want to go to trial. I need that in my file so that I know why we're in trial. Does that make sense? So I need you to sign that rejection, and then we'll get your case set for trial, and we can talk about representation, whether or not it'll be Mr. Rojas or whether it'll be someone else who can get ready for trial as well, okay? And 0323, and you're Nasir Brown? Are you gonna answer out loud or no?
Sorry, I'm just going through some things right now.
Okay, so I just need to make sure, obviously I recognize you from being here before. I'm also going to take judicial notice of the court's file and, including a letter, that you wrote to the court. In that letter, it does state from you, that you were XREA, REL or REI, I can't read it, but anyway, Nasir Lewis Brown. So you're telling me that at one point in this letter, you were Nasir Brown. And so,
No relationship.
Mr. Rojas, what is the announcement?
Judge, Mr. Brown has told me on 2 different occasions now that he does not want a court-appointed attorney. He wants to represent himself. And I think he wants to address the court about that this morning.
I go by Mujahid Bey.
That's
That's the
fine.
name, that's actually who I go by.
That's fine.
Nasir Brown is a thing of the past.
Well, and here's the thing, unless you've changed your name, and I'm gonna respect that that's what you want to be called, and that's what you have,
That's what they want.
and that's who you are, but that if you have not changed your name legally, then I have to go by that legal documentation in the state of Texas, which is driver's license, identification cards, and what you were previously known as. So let's just get past what I'm calling you and let's deal with what the cases are and what we need to do about those, okay? So for purposes of what you want to do in the future, what Mr. Rojas is saying that you want to represent yourself, I want to admonish you to a few things and then ask you some questions about that also. The first thing I'm going to tell you, 2 and 0323. And so in cause number 0322, you are charged with the 3rd-degree felony offense of assault family violence by impeding breath or circulation. That's from February 16th of 2026. What that means is that if you go to trial in that case and a jury finds you guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand at least the range of punishment and what could happen if you go to trial and you're found guilty?
Understand.
Okay. And then in cause number 26 DCCR 0323. You're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. And do you understand that as well?
Understand.
And so I have here on the tablet those plea bargain rejections that we talked about that you've signed now with Mr. Rojas. And it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. In that first case, it would be for a 4-year term in prison. And then in the state jail, injury to a child case, it would be 12 months in the state jail. And those would run concurrently, which means together at the same time. You've got every right to reject those offers and have your cases set for trial. Just want to go through this and make sure you do understand all of that. And you want to reject those offers and move towards a trial. Is that correct? All right, and so we'll get that done. And so Mr. Rojas is your attorney at this point. He's been appointed. Mr. Rojas can move forward with your trials, or because he handles a lot of cases for me as a court-appointed attorney, I can replace him today with a different attorney who could begin preparation for trial a little quicker. Is that okay with you, or do you want to keep Mr. Rojas?
Actually, I'm gonna represent myself.
Well, I understand that. So let's at least for this, if you'll indulge me at least for the beginning, so that you can take a look at all of the evidence some more with either Mr. Rojas or another attorney. Can I leave an attorney on at least till we get a little closer to trial, and then let's talk about if you really want to represent yourself when it gets closer?
Well, the question that I asked Mr. Rojas is not even answering. He's not even giving me any information that I'm seeking, like the discovery.
Right. So, well, I'm sure Mr. Rojas is relaying to you everything he can, You're not entitled to get copies of everything by law in Texas. And so he will give you copies, or whoever your attorney is will give you copies of what they can give you. Anything else, they can go over with you, explain it, let you read it, but they cannot leave copies with you. So again, do you want me to appoint a different attorney and you can visit with them about your case instead of Mr. Rojas?
Is it true that you have a grand jury indictment without the person being present?
Yes.
Is that considered a waiver of your grand jury, or is that
Is it considered a what?
a waiver?
It's just how the process works.
I'll have to give me a difference, right?
All right, so Mr. Rojas will be released. We'll appoint someone today. They should be out to see you very soon to go over everything and begin preparation for trial with you, okay?
You got a name,
I don't know who it's gonna be yet. We have a list of attorneys. We'll figure that, the clerk will figure out who's next on our list, and we'll have that done today after docket. When she has some time to look at that, and so we'll let them know that you're waiting to see them. They'll be out very soon to go over everything. All right, you can go back with the bailiff. Thank you. Thank you, Mr. Rojas.
Thank you, Judge.
Yes. I don't know. We're gonna need to, go through, correct? Go through that list and see. He's pretty good at that. Mr. Rojas, you've got Byron Morris. It's a sentencing. He's with the right tone, giving in a little bit, so.
Small crowd.
Yeah.
Yeah.
Morning.
That may just be because you're here.
I'm sure.
We have a witness.
Okay,
Huh?
We have a witness in this case.
And, okay, is it okay just to come up and do it this way? All right, sir, are you Byron Jamal Morris? And Mr. Morris was previously in court, entered pleas of true to counts 2, 3, and 5 in a motion to adjudicate on probation for the second-degree felony offense of burglary of a habitation. I've received an updated pre-sentence report. Have you both received and reviewed that report?
We have, Your Honor. Yes, Judge.
Are there any additions or corrections to the report?
No, Your Honor. Not from the state.
All right, and so, Mr. Smith, you've got witness with regard to other, allegations?
Yes, Judge, in relation to, count number 1, as well as,
Actually, Judge, count number 4. I think we're not going to change our plan because he did admit to the probation officer that he was intoxicated, but on a different date than the arrest. So I think we can change that to a true.
So let me go through it then. So, Mr. Morris, you pled not true to counts 1 and 4. Count 1 alleges you committed that new offense of public intoxication November 6th of 2025. And in that case, you still want to remain with your
That's still
not true. And then count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. And is that true or not true?
Yes, ma'am.
It's true?
Yes, ma'am.
Okay, so I will change your plea in count number 4 to true. And Mr. Smith, you have witness with regard to count 1.
yes, Judge.
You may call your first witness.
State Falls Officer Jensen.
Yeah, if you'll just kind of slide around a little bit. We'll just do this informally. Thank you, sir.
Morning.
Good morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Would you state your name for the record and spell it for the court?
Officer Michael Jansen, first name Michael, Michael, last name Jansen, Jantzen.
And how are you employed?
I'm employed by the Beaumont Police Department.
And what is your occupation?
I'm a police officer.
How long have you been a police officer?
A year and around 3 months.
Are you a certified police officer in the state of Texas? What training have you received to become a certified peace officer?
I've been through the basic police officer.
Can I ask y'all both to speak up? Your back's kind of to the court reporter as well. Thank you.
And what do? You said you're a patrol officer?
Yes.
What is a duty job description for a patrol officer?
General patrol, respond to calls for service, any number of calls throughout a shift. Could be honestly, anything.
Okay. Were you working in that capacity on November 6th of 2025?
Yes, sir.
And about 11:38 in the evening, did you receive a dispatch?
Yes, sir.
And what, if anything, did you do as a result of that dispatch?
Immediately began operating my department issued patrol car in that direction and arrived on scene.
Okay. What did you observe when you got there? And describe for the court, what location we talking about?
Yes, sir. 4705 Magnolia. It's the Swift gas station. You're dispatched there in reference to a person who was asleep at a game machine inside that gas station. We arrived on scene, entered the gas station, and observed a person asleep at the game machine. Attempted to arouse him by verbal stimulus. I then reached under his chest and provided a physical stimulus to his chest. He did not wake up. At that point, he woke up after a few more conversations between my partner and I, and he woke up, immediately smelled the smell of alcohol emitting from his broken person, observed bright glassy eyes, and as we stood him up, we walked him out, to the police car and observed the unsteady gait as well.
Okay. In your opinion, did he appear to be impaired or intoxicated?
Yes, sir.
And did you feel like that was from alcohol and or other substances?
Yes, sir.
Was he impaired to the point that he appeared to be a danger to himself and to others?
Being that the location is in a very high crime area in the city of Beaumont, I absolutely believe so.
And do you see the person that you encountered on November 6th of 2025 at the Swift gas station here in the courtroom today?
Yes, sir.
Would you point to him and identify an article of clothing that he's wearing?
An orange jumpsuit.
Gonna let the record reflect. He has identified the defendant in this case.
The record will so reflect.
And did you place him under arrest for public intoxication on that day?
Yes, sir, I did.
That's what Mr.
Thank you, Mr. Rojas.
So he was in a high crime area and that makes him a danger to himself or others.
Yes, sir. Being that he was asleep in that gas station, that I've responded to several calls there for violent crimes. He was unable to be aroused by myself and another officer. I believe that somebody could have stolen any number of items from him or assaulted him or been a victim of any other
What was the original call for?
person asleep at a game machine.
Nobody said anything about anybody being violent or any fighting or anything like that, right?
Not at that time.
Okay. Was there ever at all during this call?
Not during that call, no, sir.
Okay. And when you were finally able to wake him up, he wasn't argumentative or disruptive with you, was he?
He woke up as a person would, surprised that there was two police officers. I feel like that's a normal reaction. All of a sudden there's two police officers with their, presence right there. But I was able to take him in handcuffs immediately based off of that reaction. Felt for him.
And you said you did the chest, what's it called? The chest rub?
Like a sternum rub.
The sternum rub. Most people wake up immediately from that, don't they?
Yes,
Even intoxicated people.
general in my experience.
In your experience, do you know of any kind of what would cause it? But you said he did not immediately wake up from that. What in your experience would cause somebody to not wake up immediately from that? If you know.
Any number of intoxicants in their system.
Okay. Could it also be due to seizures, maybe?
I'm not.
You don't know about that? Okay. You'll agree with if anybody in a high crime area is in a little bit of danger, right?
Yes, sir.
I pass the witness.
Anything
No further
else?
questions, sir.
Any objection to Officer Jansen being excused?
There you are.
Thank you for being here, sir. Any other witnesses?
No, Mr.
Right, argument with regard to count one,
I can call Mr. Morris on it.
on count one?
Yes.
Sure, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, go ahead.
Byron, you heard the officer's testimony, right?
Yes, sir.
Okay, and you and I have talked about this before, about count one, right?
Yes, sir.
Tell the judge, were you intoxicated on that night?
No, sir.
Okay, why were you asleep on that night?
I think I had a seizure almost and
Okay, and you are prone to seizures, aren't you?
Yes, sir.
And in fact, I think that's in the updated PSI that you do have seizures and the probation department knows about that.
Yes, sir.
Okay. Now, the officer says he smelled some alcohol. Why would he be smelling alcohol on your breath?
All that I kind of remember was I might have had an open container in the car. But I really don't remember.
Okay, so you admit that you might have been drinking alcohol on that night,
Quite a little bit, sir.
but you don't think you were intoxicated?
No, sir.
And, well, pass the witness, Judge.
All right, Mr. Smith?
So, Mr. Morris, you're saying that you had a seizure, and as a result of the seizure, you had passed out to the point that verbal stimulus and physical stimulus did not arouse you, correct?
Yes, sir.
Do you take medication for your seizures?
Yes, sir.
What do you take?
Careful.
How often do you take it?
Milligrams,
How often do you take it?
twice a day.
Twice a day. Do you know how alcohol affects that?
Not really.
So you have no idea what alcohol does to that drug. It's an anti-seizure medication. Yet you consume your medication twice a day and use alcohol at the same time.
Well, I don't drink like that, y'all, sir.
You don't.
No.
Well, you drink often because you were pled true to count 4, and you just admitted that you were drinking on the day that you were arrested. Right?
Yes, sir.
No further questions.
All right, any other witnesses with regard to count 1?
No, Your Honor.
Any others rebuttal or anything, Mr. Smith? At this time, based on the evidence that's been presented, Mr. Morris, I am going to find count 1 true. That you did commit the offense of public intoxication on November 6th of 2025. So with regard to sentencing, Mr. Rojas?
Judge, Mr. Morris has been on probation since 2016. I think his probation has actually expired since March. It appears that from March of 2016, he was doing well until that first motion to revoke was filed in October of 2020. Notable, I think, as you can see from the updated PSI, at that time, he had some support of both of his parents, who unfortunately passed away, I think the following year, 21, when Mr. Morris was, at that point, was sent over to Safe P Relapse in March of 21. And then it looks like at that point, his parents passed away. He went from March 21 to December of 23 until the second motion to revoke was filed based on a new offense that was ultimately dismissed. And that motion was resolved by jail sanctions and continued on probation. And that brings us to this new motion, which is filed from, I think in February of this year with the new allegations. So he's been on probation for 10 years. Other than this new PI, he hasn't committed any new offenses, even though one was alleged. That case was dismissed in 23. It's unfortunate, I think, that his parents passed away because it looks like they were the support for him. They were able to give him some guidance while he was on probation. He was doing well while they were alive. And even after they passed away, other than administrative violations and this new admitted drug use and alcohol use, which is serious. I understand those are violations of probation, but he seemed to be doing well until this new motion was filed. I don't know what we can do with him, Judge, because probation's expired. My recommendation, or I guess what we would ask the court to do is to let this time that he's been in jail serve as sanctions and let his probation expire.
All right, thank you, Mr. Smith.
Judge, I believe the recommendation probation officer is absolutely spot on. I think he's taken advantage of the court's leniency. We've sent him to Safe P twice. He's been in drop. He's done the moral recognition therapy. He has not gotten any benefit from all the programs that have been offered and completed. He blames the fact that he can't act like an adult because he doesn't have people to tell him what to do, but he's an adult. He shouldn't have to have people tell him what to do. He's been given every opportunity, and just letting it expire would be not justice in this case. We believe that probation should be revoked and he should be sentenced to time in TDC, understanding that he will get credit for the time that he successfully completed safety. So we would ask for a significant amount of time in prison.
Thank you, Mr. Smith. Mr. Block's here and you have your updated report. Is there anything else that you would like to add, sir?
No, man.
All right, thank you. Mr. Morris, Mr. Smith is absolutely correct. I'm looking back at that original PSI, and the original PSI wasn't even agreed. It was a cap of 8 years in prison. And on that day, I gave you the opportunity for this probation. And you have had multiple, this is your third motion to revoke. So it hasn't all gone well. And the fact that you've been given those opportunities at SafeP twice and you're still doing what you're doing, I'm going to again so I'm finding count 1 true, find that you entered your pleas of true to counts 2 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. You're lucky that the agreement in this is for a cap of 5 years. You know, the cap went down from the original, which is usually doesn't happen. I'm going to follow this agreement, but you're very lucky. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you. You can go back with the bailiff. Excuse me, Johnny Segita, Mr. Rojas, it's a sentencing.
Johnny, was Donita.
Huh? It looks like one, but it just came from a store. But somebody found it.
We still have libraries.
No, it's I think it was like a bookstore, you know, an old bookstore. Somebody just gave it to me to read. It's an interesting one. All right, sir, you, Johnny, is it Segita? Segata, and Mr. Segata is here in cause number 26 DCCR 0795. Entered a plea of guilty previously to burglary of a habitation. There was an agreement for a cap of 10 years in prison. I've received the pre-sentence report, and have you both had an opportunity to review that report?
We have, Your Honor. I have, Your Honor.
Any additions or corrections?
Judge, I guess, given by the statements of Mr. Segata, I was able to speak with him at the jail yesterday, and at the time of the plea, he was thinking that possibly he had said something on the night of the offense that people inside the house may have thought he intended to commit an assault. He's since the plea, he's had time to think about it. He has since changed his opinion. He doesn't think he said anything on that night that would make them think he committed an assault. It was not his intention. He's saying now to go in and commit an assault. He would like to withdraw his plea.
Mr. Nichols?
Judge, he knew what he was charged with and what he did when he pled guilty. He also has the benefit of a dismissal on the other charge related to this. If he wants to go forward, we'll go forward.
So you were in custody when you pled guilty. Why did you do that?
Well, I didn't know that they was accusing me of trying to assault anyone, because that wasn't the case at all.
Well, I mean, you went over, I told you what you were charged with, and Mr. Rojas went over all of that with you before you pled guilty.
It just, all I got out of it was a burglary of habitation. I mean, I didn't go in to assault anybody.
So here's the thing. If I allow you to withdraw your plea, there will not be a plea after today.
Yes, ma'am.
You will go to a trial, a jury will determine it. There will be no negotiations. Everything is off the
Yes,
table.
ma'am.
Because we've gone through this
Yes,
process. So there's no change in your mind later. Do you understand?
Yes, ma'am.
And is that what you want to do?
Yes, ma'am.
All right, then I'll allow you to withdraw your plea of guilty. We're gonna get your case set on the trial docket. So Mr. Segata, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. I can appoint another attorney who could begin getting ready for trial a little quicker. Is that okay with you?
Well, I have a choice of keeping them.
Sure, uh-huh.
Yeah, I would like to keep them if
All
that's
right,
all
then
right.
Mr. Rojas will begin preparation for trial. All right, you can go back with the bailiff. Ms. Holmes?
Yes, Your Honor.
You've got Joseph Allgood.
Yes, ma'am. That's the cap. That's what you want to put for. Yeah.
This.
Good morning. Are you Joseph Allgood?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Allgood, in cause number 26 DCCR 0272, you're charged with the state jail felony offense of attempting to take a weapon from an officer from December 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 9 months in the state jail, which means if we go forward with this, you're leaving your punishment to me. I can give you 9 months. I can give you less. I can consider probation. It'll all be determined once we come back for a sentencing hearing and I have all the evidence. You have every right to have a jury come in and do 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Allgood's not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that report done, and then we'll come back later. Anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back for sentencing.
Yes, ma'am.
All right, you go back with the bailiff.
Judge, I'm sorry. just
Yes,
before-
hold on just a second,
Before
sir.
the defendant goes, I just wanted to let the court know this is a little bit different than our
Mhm.
typical caps. It's gonna be the state who's asking for probation and the defendant time. In this case, just so the court is aware, that I think Ms. Holmes and I both agree that we hope to try to get him some help with his mental health issues that obviously contributed to this offense. So I just wanted the defendant to be aware that that's probably what both of us will be asking for. He's the one who's asking.
Okay, all right, we'll see where we get it next time. All right, you can go back with the bailiff.
Yes, ma'am.
Cody Cesar Cesar, do we?
He's in federal custody.
And
Okay.
then I have an update on that, Judge. I asked Ms. Holmes to keep it, the other Ms. Holmes to keep it on the docket, just so that we could get an idea on his federal status. He has pled to 2 drug cases. He's awaiting sentencing in Judge Crone's courtroom as of 2 weeks ago. That's kind of where we are on it. Brittany and I have spoken. Typically, I would say that case would resolve ours, which involved a gun. I thought they would probably take it on the firearm. Obviously, they did not. He's gonna need to get at least some sufficient time over there for it to dispose of ours because it's habitual here, but if he gets somewhere in the 8 to 10 range in the federal case, we should be able to take care of it without a writ. Otherwise, as soon as he's sentenced over there, we'll writ it back.
Okay. Do you know when that plea was? So that I know about how long.
I have the paperwork.
Yeah, that way, because their PSIs are taking a good 4 months at
Right.
least. So I can at least reset it for, just let me know
Yeah,
what,
okay,
and
I'll
I'll-
look in the paperwork.
okay. I'm gonna say at least 90 days.
Okay.
And then we'll kind of see where we are at that point.
Yes, but Investigator Hinton was able to get all that for us. So
Good.
I'll see if I
Okay.
can find it in the paperwork.
Thank you. Daniel Eli. Ms. Holmes?
Yes. Eli, Ashley's gonna put some on the record and it'll be dismissed.
Good morning. Are you Daniel Eli? And this is cause number 25 BCCR 0898. Mr. Eli is charged with continuance violence against the family. And what is the announcement?
Judge, it was our position in this case that if the misdemeanors were disposed of with some specific conditions with respect to no contact with the complainant, et cetera, that this case would be dismissed. That has been done in June, and he is on probation for those cases. He also has obviously been in custody for some period of time that we would address as a sanction both for this and those misdemeanors, and just ask the court to admonish him, even based on this dismissal, that the other cases that arose out of that still come with terms and conditions that he's to follow over there. I think he just needs a reminder.
So, Mr. Eli, it sounds like the state's going to file a dismissal in this case because you've taken care of the other underlying offenses. I cannot express to you how serious it is that you follow all of those rules on those probations.
Yeah.
You need to stay away from the victim in those offenses, completely away. Do you understand? No contact, no communication. She can't give you permission to violate those orders. So she can't say, it's okay, come on over, I'm giving you permission. That judge down there has to give you permission. All right, you
Yeah.
understand? Okay, I'll sign it when it comes through. We go back with the bailiff. Jesus Guerrera.
Jesus Guerrero.
He's playing to the full indictment.
Okay, thank you. Good morning. Are you Jesus Alberto Guerrera?
Yes, ma'am.
Or Guerra?
Yeah.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Guerra, in clause number 26, DCCR 1068, you're charged with the state jail felony offense of theft of material, aluminum, and that's from January 16th of 2026. Your indictment alleges that you were previously convicted of deadly conduct, a second-degree felony, aggravated assault, a second-degree felony, 3 cases of aggravated assault, on May 5th of 2011. And after all of those were final, you were convicted of burglary of a habitation, a first-degree felony, May 31st of 2019. And how do you plead to that charge?
Yes.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with? Did you plead guilty because you actually did it?
Yes.
All right. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 10 years. You would be ordered to pay a $500 fine and ordered to pay restitution that would be determined before we came back for sentencing. Is that your understanding of your agreement?
Yes, ma'am.
Well, we'll just wait. It looks, obviously that looks,
And that's why our original offer was state jail time based on the age of those priors and the pretty considerable state jail time based on the age of the priors. He wanted the opportunity at probation, but we know we have the PSI to kind of.
okay,
coach and
I'll take a
that.
look at it and see if there's anything, because the last one was only in 2019. It was a free felony.
And
And
he received the minimum.
yeah,
He
they gave me
did.
5.
Okay. All right. So do you also understand, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Guerra is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Thank you. Mary Robinson.
Mary Robinson, we're just going to go through the motion. I requested updated PSI.
Okay.
Right here. Right here.
Good morning. Are you Mary Robinson? Can you say yes or no for me?
Yes.
Thank you. And Ms. Robinson, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Robinson, in cause number 24, DCCR 1116, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 2nd of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 10-year deferred probation. Is that correct? Can you say yes or no for me?
Yes.
Thank you. It alleges that you violated your probation. Count 1 says that you committed the new offense of criminal trespass, May 7th of 2026 in Jefferson County. And is that true or not true?
That's true.
Okay. Count 2 alleges that you failed to provide verification of performing the community service hours required. And is that true or not true?
True.
Count 3 alleges that you didn't enter and successfully complete the forensic program at Spindletop. Is that true or not true?
That's true.
Count 4 alleges that you didn't enter and successfully complete the anger management program. Is that true or
Yes,
not true? Count 5 alleges that you did not enter and successfully complete a parenting course as ordered. Is that true or not true?
That's true.
And then count 6 says that you're behind in your court assessed fees. Is that true or not true?
That's true.
Okay. Did you enter your pleas of true to all of those counts freely and voluntarily?
True.
And did you plead true because they're all actually true?
Yeah.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. We'll get an updated pre-sentence report and then we'll come back. Anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back.
Okay.
Okay, you can go back with the bailiff.
Oh, we friend.
Oh, I'll take back.
Mr. Lewis, you've got Avriana Dorsey. It's a sentencing.
PC three is looking for Brittany, and she was leaving and everybody ran out and up to Brittany.
Oh, okay. I'll take care of that red hearing next. For Buddy, you're here on a red hearing for Buddy.
Oh, yes. Wait, no, about the way show. Yeah. Oh, no, Elon. Yeah, okay.
Good morning. Are you Avriana Dorsey?
Yes, ma'am.
And Ms. Dorsey was previously in court, entered a plea of guilty to burglary of a habitation, first degree felony. Have received the pre-sentence report. If both of you had an opportunity to review that report.
I have Judge.
Yes, Your Honor, we have.
Any additions or corrections?
Nothing. Not from the state judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. I also noticed in here that there was $450 in restitution that was requested. Did you
Yes.
have any other information about that?
Judge, I think that was just damage to the door and everything, when she came in, and we are asking that be added as payment of restitution.
I'm going to order that $450 in restitution as well. Ms. Dorsey, this is a great opportunity for you because you don't have a felony conviction on your record. This is a very serious offense. And so if you do everything you're supposed to, when you complete the probation successfully, the case will be dismissed. You'll never be a convicted felon. The other side of that, though, is extremely serious because if you violate any condition of probation, you can be brought back into court, found guilty, and sent to prison for between a minimum of 5 years up to 99 years of the rest of your life. Do you understand? ISF is meant to help you make better thinking decisions and things like that. So please take advantage of that program. Listen, learn, so that when you get out, you'll be successful. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you.
Hey.
Let's see. DeMarcus Elam. Ms. Holmes.
Marcus Elon.
I haven't, and I really need to. Need to ask.
What is this set post?
A bond, a writ for a bond.
This is the code from Mr. Blanc.
Right, are you DeMarcus Elam?
Yes, ma'am.
And Mr. Elam is charged in cause number 26 DCCR 1221 with the first degree felony offense of murder. And Mr. Reynolds was appointed to represent Mr. Elam. Ms. Holmes has stepped in while Mr. Reynolds is out for some time and has filed a motion asking that I reduce bond in Mr. Elam's case, which is currently set at 1.5 million. Is that correct? Is it his is 2?
Yes.
Okay. And this is the co-defendant to the Mr. Blunt that I previously handled earlier today. All right, so let me just ask the state with regard to what I did on the previous one. Is there any reason that this one should be treated any differently?
And judicial economy and all fairness, Judge, I think it would be appropriate to set both bonds at the same.
Okay, I will let you put some information on if you need or some evidence. I did grant the previous motion on Mr. Blunt's case and reduce the bond in that case to $1 million with the GPS and house arrest. I'm willing to do that based on the same information, unless you have something very different to point out about Mr. Elam other than just He can't make the big bond. and-
Right, that's it. And just as far as where he would be staying, his mother resides in Humble. And that's the home that he would like to go to.
Which I wouldn't be opposed to at all, honestly. I mean, I think that would be better to have him. Maybe not as close to co-defendant and other things going on here. Would you have any issue if he's got a
That they
GPS?
Not have, be allowed to have contact with each other.
For sure. So, I need to make sure in that other order on Mr. Blunt that I write in, on that order. No contact with, DeMarcus Elam. So what I'm gonna do then, Mr. Elam, is I'm gonna grant the motion. I'm going to reduce your bond to $1 million. Condition of that bond is you have absolutely no contact or communication with Mr. Blunt. I know you guys are incarcerated here together. I want to make sure their dates are on different dates in the future if they're still in custody, so that they're not back there together. Also, a condition of your bond will be that you will be on house arrest and have to wear a GPS monitoring device. You'll have to give that address. I'm not making it where it has to be in Jefferson County. So if you make that bond, you can go. I want it to be within Harris County or Jefferson County. You can't just go anywhere, but I will allow you to go live with your mom in Baytown. And you'd have to give that address to your bondsman.
Well, that could
Humble.
be
I'm
Montgomery
sorry.
County,
Is
not
it Montgomery?
It's still Harris County.
It is. Okay. Whatever county it is in Humble with your mom, I will approve. Okay. If for some reason she moves somewhere different, you're going to have to get with your attorney and get with the bondsman so that I know where you are. And because we're going to be watching that GPS if you make that bond. Okay. All right. You can go back with the bailiff. Okay.
Yeah.
What's one's first name? I'm sorry. Is it Jamarcus? No, that's his son. What's his first name? JV Mildred. I got it. Yeah. Those. John Gray, Mr. Lewis.
John Gray.
You good over this?
Right. Not happy.
Okay, thank you.
Just if I may put a couple things on the record whenever you're ready.
Yes, ma'am. Good morning, sir.
Morning, ma'am.
Are you John Gray?
Yes, ma'am.
And this is cause number 25 DCCR 1396, Ms. Malfino.
Judge, we have extended an offer of deferred probation in this case, which the defendant has accepted. I wanted the court to know that I have been made aware yesterday, actually, of the fact that he is also being investigated by Harris County detectives for the same type of offense. This is an impersonation involving some labor law issues and posters, et cetera. He was here on bond originally. I think he tested positive, if I recall, and that's why he's been in custody. It was my position to offer that same probated term. I reached out to Detective Williamson yesterday. He agreed with that, but just wanted the court to know those things are in the works. If you see him in the PSI, and that would be the reason for the state's position to be that we oppose a bond, even though it's a deferred
Sure.
probation.
Okay, thank you. And will your client waive the formal reading of the indictment?
He does, Shane.
Mr. Gray, you're charged with the third-degree felony offense of impersonating a public servant from July 14th of 2025. And how do you plead to that charge?
That's good.
There's no, I guess, guilty. Either you did it or you didn't do it. Are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes,
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and any other conditions that would be ordered, especially after a PSI, and I see any and all issues that are going on. Do you understand? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes,
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Gray is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. So the probation department can do a pre-sentence report and that'll give us more information about you and your case. And then we'll come back later for sentencing. All right, you can go back with the bailiff. David Hale. David Hale. We're going on. Let's see. Just count 1, the first degree, or
Count 1, the lesser included.
Listen.
We weren't sure which one to mark, so we went both.
okay, lesser included of.
Right. And he will have a hold from Liberty County and proceed there.
And this, it'll be the second degree.
Yes.
Yes.
All right, so are you David Hale?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
Yes, Judge.
Mr. Hale, in cause number 26 DCCR 0106, the state has elected to proceed on count 1 only. And in that count, to the lesser included offense of a second degree felony robbery from December 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1.
Yes.
Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've reached with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tender number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hale's not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser included offense in count 1 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the second degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir.
Thank you.
Getting there. Angela Reyes. Good morning. Are you Angela Reyes?
Yes, ma'am.
And this is cause numbers 26 DCCR 0265, 0787, and 0788. Ms. Reyes was previously in court, entered pleas of guilty in those three cases. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yeah, Judge.
Yes, Your Honor, yeah.
Any additions or corrections?
No complaints.
No, Your Honor.
All right, Ms. Reyes, I'm going to find that you previously entered your plea of guilty in each of these cases freely and voluntarily. And cause number 26 DCCR 0265, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation, and I'll go over some of those in just a minute. And cause number 26 DCCR 0787, find sufficient evidence to find you guilty. However, I'm also going to follow the agreement that you made and defer all proceedings and place you on probation for 10 years in that case. Same thing, you'll have a $1,000 fine and be required to follow all of the rules and conditions of probation. Actually, hold on, there's only a fine in 26 DCCR 0265. There's not one in 0787. And then in 26 DCCR 0788, also find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation in that case. Part of those rules and conditions are that you're going to be on the mental health initiative caseload, and that's to give you whatever help you need so that you can be successful. The important thing about that is if they say that you need counseling or medication or whatever it is, whether you feel like you need it or not, it's going to be ordered that you do it, okay, for your benefit. And if you do everything that you're supposed to while you're on this probation, this is a great, great opportunity for you. You don't have a felony conviction on your record. You'll be able to finish this without any issues, and the cases will be dismissed hopefully at the end if you are successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. In 2 of your cases, you could be revoked and sent to prison for 2 to 10 years. And in the other case, you could go to prison for 2 to up to 20 years. Do you understand?
Yes.
I will sign dismissals and all of the other pending cases as part of this agreement. I'm going to hand you, in these cases, the trial court certifications that shows that these are agreements that I followed, and so you've waived your right to appeal.
Yes.
Good luck to you, ma'am.
Thank you.
We're gonna miss all of them.
Eric Segrist. Any answer?
Judge, I think the intent is to add him to the mental health caseload. I don't know if you want us to do paperwork or anything on that. And also consider a jail sanction.
So plead to the motion and then just,
It's only one count. It was trying to contact her from the jail.
Yeah, and that was prior to him being on his medication.
okay. It's just- Good morning. Are you Eric Segrist Jr.?
Yes, Your Honor.
And Mr. Segrist, the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Will your client waive the formal reading of the motion?
He does.
So let's just go through that motion. Mr. Segrist, in cause number 25, DCCR 1836, I have a motion to revoke your community supervision. Shows that you were placed on probation May 18th of 2026 for burglary of a habitation, and that was a 10-year sentence that was probated for 10 years. Is that correct?
I thought it was probation for 5 years.
Shows 10.
It was 10. It was 10 years.
It was 10.
Yes, ma'am.
I thought it was 5.
Okay, so it looks like it was for 10. And then it alleges that you violated your probation. The only count is count 1. It shows that you violated the conditions of your probation by attempting to contact the victim of the offense, Perla Munoz, through the smart communication messaging system at our jail, May 26th of 2026. And is that true or not true?
It's true, Your Honor.
Did you enter your plea of true to count 1 freely and voluntarily? Is there another?
He's right, Judge. It was.
Is it
10
5?
probated for 5.
Okay.
10 for 5.
Okay, well,
I had to
with
double
this,
check it 2 places and it's 10 over 5.
okay, thank you. Well, thank you for bringing that up. Does the state wish to amend that motion?
Yes, Judge.
Does any objection to
Okay.
that amendment?
Line for the second 10 and like 5.
Yeah, that's easier said than done on a computer.
Like, you go backwards, it's all gonna be easier and better.
It's also like the tiniest writing ever. Okay, so 10-year sentence that was probated for 5 years. And did you enter your plea of true to count 1 freely and voluntarily?
Yes, Your Honor.
And did you plead true to that count because it's actually true?
Yes, Your Honor.
And so it's my understanding that you guys have reached an agreement, Mr. Smith and Mr. Lewis.
Yes, Judge. He's just started on probation. We would ask that the court admonish him that he cannot have any contact with his Munoz. And that we will we offer to keep him on probation. Make sure he's on the mental health caseload, stays on his medication, and has no contact whatsoever.
So, Mr. Segrist, I have a feeling we probably talked about this at sentencing, that you weren't supposed to have any contact or communication with her. And 8 days after you contacted her, or at least tried to, you are going to end up in prison for. If you do it again, we will not be here with anybody saying, let's give them medication, let's help them, let's put them in programs. I'm not going to hear it. If you try to contact or communicate with her in any way, you're looking at minimum 2 years up to 20 years in prison. And I'm going to take it very seriously. I can tell you that. Do you understand?
Absolutely.
So whatever the relationship was, it's done.
Yes, ma'am.
And there's no reason for you to ever talk to or communicate with her again. If you do, you'll go to prison. It's that simple.
Yes.
Okay. So I'm going to find that you entered your plea of true to count 1 freely and voluntarily, find that count true, find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. Again, same condition, not to have any contact or communication. Any issues, you'll be on the mental health caseload if you need any help with whatever it is. Probation's there to help you do that, okay? Yes.
I was wanting to ask you, if I could have any access to like a mental hospital or prior release, after I get released.
Talk to probation about that as soon as you're released,
Yes.
because they have options. And if there's something that they can find for you that's inpatient, it's hard to find some inpatient. There's outpatient stuff that you can do. But there might be something that they can do. You need to talk to them about that immediately, okay?
My probation officer?
Yes.
Okay.
As soon as you get out and you're released from custody, go straight to probation, make that appointment, talk to them, explain that you feel like you need some help up front, so that you can be successful later. And I'm sure they'll do everything they can to do that.
Yes. Sir.
Okay,
Thank
thank you.
you.
Go back with the bailiff. And Jody, if you'll just make a note to let his probation officer know that,
Officer is not officer.
okay,
So
that what he's asking for is, thank you.
Judge, could you pronounce the 45-day jail sanction in this case?
Oh, you didn't say that out loud when he was standing there. Y'all might have said ahead of time
Yeah, we said it ahead of time. We said it was a 45-day jail sanction.
with credit
With
for any time.
Correct.
So there will also be,
He's still got another 2 or 3 weeks to get to serve.
right, yeah.
Big judge.
Yeah, so Mr. Seacrest, it was also part of that agreement or recommendation that you serve a 45-day jail sanction as a part of that for you violating the probation. So I am going to order the 45-day jail sanction. I think you have some time left on that. You can have probation. If you can have them maybe go out there while he's there so that as soon as he gets out, maybe there's something in place. That would be great. Thank you. All right, you can go back with the bailiff.
Mouse.
Brad Thibodeau. Excuse me.
Right, Thibodeau.
Okay. Name right. Come on up. Good morning. Are you Brad Thomas Thibodeau?
Yes.
And will your client waive the formal reading of the indictment?
He does, yeah.
Mr. Thibodeau, in cause number 25 DCCR 0542, you're charged with the state jail felony offense of criminal mischief, impersonating a public service. Is it impersonating or impeding? Hold on. Impeding, sorry, causing impairment or interruption of public communications. And that's from March 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I'm sorry. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney's office, you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. There would also be restitution in the amount of $1,848. Is that your understanding?
1,480.
84.
1,484.
Y'all wrote 1848. What's the amount?
All right. 1484.
Okay. $1,484. Is that your understanding?
Yeah.
Speak up, please.
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thibodeau is not competent?
No, Judge.
What is the state's position with regard to waiving pre-sentence?
We've agreed, Judge. He has a 1999 delivery of controlled substance. He received 10 deferred on that. I don't have any indication that he did not successfully complete it, unless he does. And in 2016, he had 20 days on a criminal trespass. With the restitution determined, I have an address for the Windstream Communication Company on 2nd Street in Winnie. It's directly there, so I don't have a problem if you don't waive.
All right, so I'm going to waive the pre-sentence report, Mr. Thibodeau, and find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay the fine of $500 as well as restitution in the amount of $1,484, and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, found guilty of the offense and sent to the state jail for anywhere in the range of punishment, which is between 6 months and up to 2 years. Do you understand? It's very important that that restitution get paid from the beginning. A lot of people think, well, I've got 5 years, I'll pay it later. I want you to make payments towards that restitution immediately. Even if it's a little bit every month, get it paid off, okay?
Yes, ma'am.
All right, thank you. Good luck to you, sir.
Yes.
That's the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. Hakeem Manuel Thomas. What's the temp on it here?
It said it 65, 69.
Yeah. Good morning, sir. Are you Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Well, Judge, as far as the defense side, we're not ready to proceed at this time. There's some supplemental discovery I've been made aware of that we're looking to get copies of. I guess as soon as I'm able to get that, then I'll be able to assess it and go over with my client, and so we can prepare from there. But we're still
What's?
Two things, Judge, if I may.
Mhm.
I had a vacation letter in for next week that I submitted in
Oh,
December.
okay.
I think maybe this one just accidentally tagged along with.
Well,
Defendant.
and sometimes what we'll do is leave it on a pretrial, and that way if something gets taken
Yes,
care of.
and it happened to be a good thing in this case, and Mr. Wilkerson's here, he represents the co-defendant. I've been working diligently with my investigators to try to get some rather large supplemental discovery from different agencies, not even in county, DPS in Chambers County Sheriff's Office, video from there. They have sent all that. I received an email with a lot of that yesterday. There's also some things in Fort Bend with respect to older offenses. There's a continuous offense at Port Arthur that goes along with this. So I would prefer to try Mr. Wilkerson's client first. It is set on August 17th. I'll make sure both counsel has that discovery by this week, as soon as I get it all downloaded and get it to them in the appropriate format. But that's kind of where I am.
So everybody should have all of it this week.
Everything that's come in. Yes.
Okay. All right, so let's do this. I'm just gonna reset Mr. Thomas a normal reset on the trial docket. That gives, since you're on vacation, gives you plenty of time. And then Mr. Wilkerson's, obviously we'll deal with that in about 3 or 4 weeks, which hopefully will give you plenty of time, Mr. Wilkerson, to go over everything, and we'll see where we are on that case. All right, you can go back with the bailiff, sir. No, on a, keep it on the trial. Stacy Tyler.
That's what I want.
Are you sending all those dismissals on Reyes?
It's mine, Judge.
Okay.
I was told they've already been done.
Why are they on the document? Usually they don't show up if I've already signed it. Okay. Okay.
Bless you.
Bless you. Good morning. Are you Stacy Tyler? And will your client waive the formal reading of the indictment?
She does, sure.
Ms. Tyler, in cause number 26 DCCR 0800, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 30th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means if we go forward, you'll be leaving your punishment up to me. I can sentence you to 15 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not. And then you could leave your punishment up to them if they found you guilty. If we go forward this way, you're waiving that. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Tyler is not competent?
No objection.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And then we'll come back later for that. Anything that you think is important for me to know, get that information to Mr. Lewis and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you.
Jim Meldred, Willridge. Yeah, what do we do? Where are we on this? Yes, we are.
The James County case has finally been assigned to a prosecutor yesterday,
Oh, good.
so I was able to talk to them. They wanted some time to get with the state here to
Okay.
get some feedback. on what
So
they
just a
see.
normal reset.
It's normally said.
And I did send that discovery to you,
Yeah.
right? Or not not via the normal channels,
Yeah.
but just through an email.
Okay, good. All right, you're Jim Meldred and Willridge. And so, Mr. Willridge, what we're gonna do, it sounds like the case in Chambers County has finally been assigned and they're getting some information on that. So what I'm going to do is reset your cases here. So they can, your attorney and the district attorney can talk with the attorneys over there, get all that information, see what we can work. Entered pleas of true to counts 3, 4, 5, 6, 7, 8, and 9 in a motion to revoke that probation. I've received an updated report from probation. Have you both had an opportunity to review that report?
Yes, Your Honor, and just for the court, since this report was completed, this morning, Mr. Josie disposed of the allegations regarding allegations 1 and 2, and is changing his plea to true for those.
Let me get that pulled up and we can go over it. I'm just gonna print it. I think it'll be easier. There's no agreement still. It's still unagreed. Is that correct?
Yes, Your Honor.
So, Mr. Josie, best you can, raise your right hand. Please, sir, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So, Mr. Josie, in that motion to revoke your community supervision that we went through before, it looks like the punishment then was a 2-year sentence that was probated for 5 years. And with regard to counts 1 and 2, count 1 alleges that you committed the offense of evading arrest, a class A misdemeanor, February 22nd of 2026. And is that true or not true?
True.
Count 2 alleges that you committed the offense of burglary of a vehicle, a class A misdemeanor, March 9th of 2026. And is that true or not true?
True.
All right, did you enter your pleas of true now to counts 1 and 2 freely and voluntarily?
Yes, Your Honor, I did.
And because they're actually true.
Yes, Your Honor.
All right, so I'm going to find then all of the counts 1 through 9 that you entered your pleas of true freely and voluntarily, find those counts true. Mr. Wilkerson, or do you have any witnesses? Anybody have witnesses with regard to before punishment?
Statements.
Just, yes, we have.
You may call your witness.
Defendant first, call Bradford Josie.
Go ahead.
Mr. Josie, when you were released in October 2025, what was your situation when you were released from custody to begin probation?
I was homeless and I was working towards sustaining a large responsibility of being a community liaison for Councilman Felshaw. I was working in ministry at One City Church and I didn't have a place to stay. And I was spread way too thin to have all my support in Houston. I'm from Houston.
Now, obviously, anytime you have a case like this, right, where somebody is released on probation, given an opportunity and immediately doesn't show up, doesn't do anything, the question is always, well, why should I give you another chance? What do you propose to the court will be different if you are allowed to be reinstated with some sort of sanction, some sort of treatment program?
Mhm. The lengths that I've gone to acquire solid accountability and solid backing that hold the integral witness of the community of Beaumont. Most of my accountability had been I would say sort of ineffective because it was out of reach. It was in Houston. And so what I've done is what I've been able to accomplish.
How old are you?
I'm 36.
Okay. All of this, my accountability and you're 36.
Yes.
You're not 18. So I need to hear a little more about the answer to Mr. Wilkerson's question.
So specifically, if the court were to reinstate you with some sort of sanctions, what is your plan upon discharge?
My plan upon discharge is to attend Unity Treatment Center and through Spindletop, follow up with a primary care doctor that could have me on the right medications. I was in Harris Health in Houston, and it was hard going back and forth from Beaumont to Houston to keep up my prescriptions, and that's how I went into that lapse. So I would get associated with Unity Treatment Center under Ron Harris as the director, and I would reassume my my role in
So
sobriety.
your plan then would be to transition from being incarcerated directly into an inpatient treatment facility.
Most definitely.
And through Unity, you would have a case manager then who would coordinate with Spindletop.
Most definitely.
Now, obviously, your mother will talk about what she's done, but is it your understanding that some preparation and groundwork has been laid toward those goals of getting both mental health treatment and drug treatment?
Extensive.
In terms of, I mean, when you got out the first time, you fell off the wagon.
I sure did.
And in terms of discharge from incarceration, do you think it would be beneficial for some sort of coordination of care? Obviously mental health caseload, but some sort of discharge from where you go directly from county jail to Unity?
I'm in agreement, and also I do seek to involve myself with further outpatient care that I would usually seek. I think that's one of the missing things that I've never implemented was a follow-up. I've never done a solid follow-up with anything that I've done as far as treatment. And so I would look for the outpatient program of after Unity, which would be Spindletop's outpatient program.
And then you have any objections to participating in the Jefferson County Drug Interdiction or Intervention Program?
I have no objections for that.
You understand that would add yet another layer of accountability.
Yes, I'm aware.
You also understand that if the court were to give you an opportunity and to reinstate your probation, despite these violations, that it would be a last opportunity.
Yes, I'm aware.
And So you've spent 138 days in custody now, is that correct?
Yes, sir.
All right. And instead of saying, Judge, just give me a short sentence and be done with me, you're asking this court to continue your supervision with modified terms.
Yes, that is what I'm asking for.
And you understand that, of course, that your probation will still run for 5 years and you'll be under all of these restrictions and conditions for the entirety of that time.
I am aware. Yes, sir.
Do you think that that plan has a better chance of keeping you accountable than just going to state jail and being discharged from state jail?
Most definitely. I waited out and I actually sought wise counsel outside of my own planning and my own. I don't have a background of recommending treatment to people, so I sought the insight of people who do this on a weekly basis, people who go into prisons to deliver a message of sobriety, and they all decided sort of as like a small panel that this is the best thing for me to do.
As far as medication and mental health treatment is concerned, are you currently receiving treatment while in the custody of Jefferson County Sheriff's Department?
Yes, I am.
Okay, and is your medication working?
They just changed it. It started working effectively, I would say about a month ago, before I became a full-time trustee.
Pass the witness, Sean.
Mr. Smith?
So, Mr. Josie, this consortium of experts determined that Unity was the best place for you. If the judge were to consider placing you into some kind of treatment, you told probation that you would not do substance abuse felony punishment facility. Is that correct?
I'm sorry, would you please
Safety.
You don't want to do safety. You told probation you would not do safety.
I don't want to do safety.
Okay. And you were not sure about ISF?
I'm not indifferent towards it. I would oblige.
Well, that's very gracious of you to accept something like that. That's really saying a lot, that you would allow the judge to put you in something like that. You understand you don't have the choice here? You don't get to decide where you go, that the judge does? And this magi that you've consulted, who says that Unity is the best program, you expect everybody here, and the judge especially, to agree with that just because you say it. That's fairly arrogant, isn't it?
Well, actually, I do appreciate and look forward to everyone's honorable opinion. Like I said, I don't have much experience giving any recommendation to anybody outside of sponsoring people for AA.
No further questions.
Mr. Wilkerson?
Just want to follow up, just to be clear, Mr. Josie, obviously, whatever the court does, you're going to comply with the order.
Yes, sir.
You did previously indicate that you thought that the substance abuse track of ISF would be more appropriate for you. Would you understand that the court certainly, if it is to consider, if the court is even considering reinstatement, that the court has, of course, the option of safety. There are 2 different tracks at ISF. You're aware of all of this, correct?
Yes, I'm aware.
All right, and you're asking the court to reinstate you, to give you an opportunity to continue supervision and to receive both the drug treatment, mental health treatment that you require.
Yes, I do.
Okay. You also have restitution in this case, is that correct?
Yes, I do.
All right. Pass the witness.
Anything else, Mr. Smith?
Okay.
So, and I'll allow you to call his mom, but I am gonna just tell you now that if I continue Mr. Josie on probation, it will not be at a place that's not a lockdown facility. So, the Unity House might have been something that was an opportunity at one point, but Mr. Josie hasn't, he never showed up. He never did anything, and he committed 2 new offenses, has admitted to serious substance abuse issues with some mental health diagnosis as well. So ideally, for his benefit, special needs safety is the best place because it takes care of both at the same time. And so if I'm going to consider anything, if you want to call his mom, but to go through, and I appreciate if she's done that to try to get him in a outpatient or a place that's not locked down, but that's not going to be where I am.
Right, and I understand that, Judge, and so, one of the things that we have talked about, and his mother is kind of giving her kind of last ditch effort too. She's getting older, but one of the things that we've discussed is whatever sanction, if the court were to consider reinstatement, whatever sanction the court imposed upon his release from that, to then be released into the program at Unity, so he can have that 30 days plus the access to the case manager, to work with Spindletop and.
I'm not opposed to any of that. The way it'll work is probation will make that ultimate determination on what the aftercare is and where the best place is. If it's through Spindletop, if it's through Unity, or if it's through something else, I'm gonna let them make that decision. So it's not, I'm not gonna say right now, because I don't know how he'll do and say, okay, for sure, when he gets out, it's one thing or the other. It's gonna be whatever the experts say it should be. So I'm gonna rely on them for that. All right.
I do think it's notable, Judge, and I wanted to call Miss Josie because she has put a lot of effort into this, but I think she hears the court as well, and I don't think that's going to be necessary. I do think
And I see her in the court, and I appreciate you being here and everything you've done, and I hope you appreciate where I'm coming from on this with regard to some more intensive treatment for a longer period of time.
I do think that it is worth noting that despite the fact that at this point, having already 135 days, and if he could get a short, safe peace sentence, the possibility of him being out in 6 months and being done versus going to treatment, I think it says something, Judge, that he is asking for that opportunity.
Sure. No, I appreciate that as well. And Mr. Josie, I mean, Mr. Wilkerson is right. You could take some time and probably be done at some point around the same time, probably a little later if I gave the whole 2 years. But if you really want to do better in your life and not continue to make the same mistakes that you've been making, then I would hope that you would take this opportunity and take advantage of it and be successful on the probation and not be back in court on another case. Because if you just do your time, you're not going to get, I think you need some inpatient lockdown
Understand.
type treatment. All right. Anything else then?
Nothing.
Probation's here. Yes, ma'am.
Right.
He just has those 2 new misdemeanors, Judge, that would have to be resolved.
They took care of them
Okay,
already.
Just to.
Thank you, Ms. Kane.
Yes, ma'am.
All right. So what I'm going to do then, Mr. Josie, and I appreciate that you came in and took it, responsibility for the 2 new cases as well, and that you've worked those out. That makes a difference for me as well. So I am going to find that those new pleas of true to 1 and 2 were made freely and voluntarily. Find all of the counts true, 1 through 9. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. I'm going to order as a condition of your probation that you enter and successfully complete the safety program. If the special needs safety is what's warranted, I'll let probation go through that with all of the assessments, and then that's where you would go. When you're out, you'll go through whatever recommended aftercare treatment there is. Anything you want to do in addition to what they order is great. But they'll go through with you what the appropriate thing would be, and what's also acceptable through probation and things like that. I do want to make sure you understand this opportunity. The first opportunity you got to be on probation was a big opportunity. Getting another one is, it's not going to happen again. All right, so you need to take advantage of all of this because if you violate again, you'll be looking at that 2-year sentence that you've already agreed to. Do you understand?
I understand.
All right, I'm handing you the trial court certification. It does show there was no agreement. You have some rights to appeal. You can talk to Mr. Wilkerson about that. Good luck to you, sir. Thank you all for being here.
Thank you, Your Honor.
Thank you, Mr. Wilkerson. I just wrote on it. No pages.
Judge warns defendant, representing yourself is a terrible idea. A courtroom exchange took an unexpected turn when a defendant told the judge he wanted to represent himself instead of using his court-appointed attorney. The judge didn't hesitate. She warned him that representing yourself is a terrible, terrible idea, explaining that even experienced lawyers usually refuse to act as their own attorneys because criminal trials require years of legal training and courtroom experience. The defendant insisted he understood the legal process, but the judge pushed back, explaining that knowing the law isn't the same as trying a case before a jury. She reminded him that if he failed to follow the rules of evidence or criminal procedure, the court couldn't make exceptions just because he wasn't a lawyer. Instead of letting him go forward alone immediately, the judge chose a different path. She appointed a new defense attorney to review the evidence, prepare for trial, and give the defendant another opportunity to make an informed decision before representing himself. What do you think? Should defendants be allowed to represent themselves in serious felony cases, or was the judge right to strongly discourage it? Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more real courtroom moments.